Okay, let's dive right into this explainer and unpack the absolutely crucial gateway stages of the Pakistani criminal justice system. If you're a law student, a junior advocate, or frankly, just a legally curious citizen, you probably already know that the magistrate's court is the absolute workhorse of criminal law in Pakistan. I mean, the overwhelming majority of criminal cases are tried right there. But there's this massive procedural gap that constantly confuses people. It's that gray area between the moment the police finish their job and the moment a trial actually begins. Well, today, we're going to completely bridge that gap.
So, I want you to imagine a classic courtroom scenario. A serious crime has been reported. The FIR, the First Information Report, is registered. The police have spent weeks conducting their investigation, they've gathered the evidence, and they finally submit their final report. You probably know this as the challan, filed under Section 173 of the Code of Criminal Procedure. Now, the complainant breathes a massive sigh of relief, thinking, great, the trial starts tomorrow. But wait, what actually happens next? How does a judge take up this case? Because they definitely don't just automatically start calling witnesses. There is a deeply important, highly structured judicial process that absolutely must happen first.
To get us there, here's our roadmap for this legal journey. First, from police to court. Second, understanding cognizance. Third, the 3 routes to cognizance. Fourth, framing the charge. And finally, number 5, the power to discharge.
Let's hit Section 1, from police to court, the gateway to justice. We're starting with that exact moment when the case files finally land on the magistrate's desk. The biggest takeaway right off the bat is that courts do not just blindly accept a police challan. Seriously, they act as a protective barrier before a trial can even think about starting. Think about it. Whether the police submit a positive challan, or even if they submit a cancellation report saying the case is false or untraceable, the magistrate doesn't just rubber stamp that conclusion. The magistrate's court is a critical judicial filter. Their entire job at this stage is to scrutinize the material. They need to ensure innocent people aren't dragged through the absolute mud of a criminal trial without a valid legal reason, while also making sure victims aren't denied justice just because the police maybe did a sloppy job. Moving to Section 2, understanding cognizance, or the judicial mind at work. This brings us to a really heavy legal term that we absolutely have to translate into plain English. That term is cognizance. You're going to hear this constantly in Pakistani criminal courts. Simply put, taking cognizance is a mental and judicial act of assessing the facts under Section 190 of the CrPC. It is not, and I can't stress this enough, merely receiving a piece of paper. It's the formal act by which a court becomes legally seized of a criminal matter. When a magistrate takes cognizance, they are officially declaring, I've looked at this material, I'm applying my judicial mind to it, and yes, I see a sufficient basis to initiate criminal proceedings. And actually, there's a really vital caveat here. Under Section 193 of the CrPC, a sessions court, which handles the most severe crimes like murder, cannot take cognizance directly. A magistrate must first take cognizance and then formally commit the case to the sessions court if the severity of the offense warrants it.
This quote brilliantly illustrates the guardrails set by the Lahore High Court in the landmark Bashir Ahmed case. It proves that mechanical acceptance of charges is just legally invalid. A ministerial act is literally just pushing paper from one desk to another, but a judicial act, that requires thought, analysis, and solid legal reasoning. The High Court made it crystal clear here, if a magistrate takes cognizance mechanically, without actually checking if the material discloses a cognizable offense, they're failing their judicial duty. The entire proceeding would be without jurisdiction right from the starting line.
All right, Section 3, the 3 routes to cognizance under Section 191 of the CrPC. Let's look at exactly how a magistrate is empowered to take this step.
So, while the police challan, which falls under Section 191B, is definitely the most dominant and common route in Pakistani courts, magistrates actually have a much broader toolkit. They can act on a private complaint of facts, which is Section 191A, or look at Section 191C. They can take cognizance based on independent information from someone other than a police officer. They can even act upon their own judicial suspicion and knowledge, which is often referred to as suo motu. This multi-route system is fantastic because it ensures the police do not hold a monopoly on who gets to face justice. Let's focus on that private route for a second, which is governed by Section 200 of the CrPC. Say the police refuse to register your FIR, or maybe they do an investigation but file a cancellation report, often called a B report, because they think your case is weak. This independent, private route ensures citizens still have direct access to justice. You can literally bypass the police entirely and present your complaint directly to the magistrate. The magistrate will immediately examine you and your witnesses under oath. It's a hugely powerful parallel track to the standard police challan, and it keeps the ultimate keys to the courthouse firmly in the hands of the judiciary.
Which brings us to Section 4, framing the charge under Section 240 of the CrPC. This is the absolute core of our explainer today. Once cognizance is taken, and assuming the case isn't committed to a higher sessions court, framing the charge is a massive procedural milestone. Under Section 240, it means the court drafts a formal, written document outlining exactly what offense the accused is being prosecuted for. This document is read out and explained to the accused in plain language. And at this precise moment, the accused is asked a critical question. Do you plead guilty, or do you claim a trial? If they plead not guilty, boom, the trial officially commences.
Now pay close attention to the vital legal distinction here, because the legal standards required at these two stages are entirely different. At the charge stage, under Section 240, the judge is only looking for a ground for presuming that the accused committed the offense. It's a very low prima facie standard. The judge is absolutely not declaring guilt yet. They're just confirming that there is a legitimate case to answer based on the prosecution's initial materials. But for the actual trial judgment to result in a conviction later on, that standard skyrockets to strict proof beyond reasonable doubt.
As the Lahore High Court perfectly noted in the Muhammad Rafiq case, evaluating the actual reliability of the evidence is saved for the trial itself, not the charge framing stage. Supreme Court and High Court jurisprudence consistently remind magistrates, do not conduct a mini-trial at the charge stage. You don't weigh the credibility of witnesses yet. You simply ask, if we take all the prosecution's documents at face value right now, does it look like an offense happened? If yes, frame the charge. If the accused disputes those facts, well, that is exactly what the trial is meant to resolve.
Finally, Section 5, the power to discharge under Section 249A CrPC. What if the magistrate looks at the evidence provided by the police and sees absolutely zero probability of a conviction? Enter Section 249A. This section empowers the magistrate to enact an early acquittal at literally any stage of the proceedings if they consider the charge to be entirely groundless or if there is no probability of the accused being convicted. This is the ultimate judicial emergency brake. It's designed to prevent innocent people from facing the incredible anxiety, social stigma, and crushing financial expense of a frivolous, drawn-out trial. I mean, why drag someone through months or years of hearings if the case is legally doomed from day one?
The Supreme Court of Pakistan backed this up strongly in Pervez Ahmed v. The State. They emphasized that when the prosecution's case discloses no legal offense, magistrates must exercise this power to end the proceedings. However, the Supreme Court also gave a stern warning. This early exit cannot be used prematurely. If there's still a realistic prospect that incoming evidence or upcoming witness testimonies might establish the charge, the court should step back and let the trial proceed. It requires a really delicate, highly reasoned judicial balance.
Now, if you're a legal professional, understanding the profound practical difference between these two outcomes is just essential. While Section 249A uses the word acquit for its early termination, general discharge procedures differ fundamentally from a full post-trial acquittal. An acquittal after a trial is a final finding on the merits. It means the prosecution failed, and it creates a constitutional double jeopardy bar, meaning you can't be tried again for that exact same offense on those facts. A discharge, however, is a procedural termination early on. If new, highly compelling evidence suddenly surfaces later, a discharged accused could potentially face prosecution again because a true discharge does not create that strict double jeopardy bar.
Let's take a step back and look at how all of this builds into the big picture. This timeline beautifully visualizes the entire journey we just explored. From the total chaos of day one when the FIR is registered, through the police investigation, resulting in the Section 173 challan, then that critical shift to the judiciary. The magistrate takes cognizance under Section 190, they review the material, and if there is a prima facie case, they frame the charge under Section 240. Only then, after all these threshold checks are cleared, does the actual trial begin. Understanding this sequence is absolutely essential. From that initial police report to the precise moment a judge applies their mind, these procedures form the bedrock of the magistrate's court. Whether you're prosecuting, defending, or just trying to understand your own rights, knowing that a court doesn't just blindly accept a police narrative is incredibly empowering. It highlights the rigorous checks and balances woven into the Code of Criminal Procedure to ensure fairness before evidence is even formally weighed. I'll leave you with this provocative thought to ponder. Does the magistrate's threshold power, their ability to scrutinize, demand prima facie evidence, and potentially discharge early, act as a vital shield to protect the innocent from harassment? Or if applied too rigidly, does it risk delaying or even denying justice for the victims? It's a really delicate balance of justice to consider in every single case. I hope this explainer brought some much-needed clarity to these complex early stages of criminal procedure. Please make sure to subscribe to the channel, visit Pakistan Legal Insight for more deep-dive written resources, and drop your thoughts, questions, or arguments in the comments below. See you next time.